Good evening, everybody. So, yeah, we took a little break, but now we are nearing the 3rd of October, which is the date we're anticipating that the LPC will um, publish the results. So, we are going to start prepping for oral. So, if you know that when you said for your exam, you did not do well for paper two, please start studying the theory. They like the theory a lot in the oral. So I know particularly in Free State, they ask you theory, something that was not in the question paper, questions that things or theory aspects that you would not have thought of studying for the exam is what they would ask you in the oral. So because obviously some people started studying late and began to understand the L&D, but obviously couldn't finish all of it on time, but at least still managed to get that 40. We are gonna start prepping for oral. I'm hoping that at this point you do understand the L&D. So now because we are prepping for oral, let's go through the theory. Paper two is easy, but if you did not make it for L&D in the exam, it's okay. We still have this. So today I'll just be starting the background of administration of estates just from the reporting, everything because they do ask those things in oral examinations, right? So let's start. So obviously we know that when a person passes away, their financial affairs don't disappear. Whether you are 5 feet under, hey, you're dead, will still follow you. So the law provides a structured process called what we know as administration of deceased estate. This is just to basically ensure that everyone is buried, everyone's estate is winded up in an orderly manner and fairness, right? So we have what we call the executor. So the executor plays a central role in estate administration. They must deal with matters such as debts and claims against the estate, maintenance, tax, which is your income tax, capital gains, and estate duty, and the distribution of the assets to heirs or legatees, right? So we know that since we are busy with administering an estate, the legal doc, the legislation that would come into play is your Wills Act, your Interstate Succession Act, as well as the Administration of Estates Act. So you've got three acts that come into play. In case they ask you this in the exam, please, Wills Act, Interstate Succession Act, and Administration of Estates Act. And importantly, all estates are supervised by the Master of the High Court. Right. So now that's just our brief introduction. Now, yeah, okay. So now coming to the administration process. So the administration process is basically what should be followed, how it should be followed in administering the estate. We don't know how, they can ask it in the exam, but you should know this. They've asked some of the aspects in this, so you just want to make sure that you are well prepared. So the very first step basically is the taking of instruction. An attorney or executor, whatever, usually becomes involved in one or two ways. Either the attorney has been named as the executor in the will, or if someone else has been named as executor, and that person may approach an attorney to assist them in the administration. So in practice, the attorney may therefore act directly as an executor or as an agent on behalf of the nominated executor. So attorney can act as a nominated agent on behalf of the executor. That's your step one, taking the instruction. After this, then comes consultation with the family. This is very important because it sets the tone for the entire administration process. During this consultation, the attorney obviously gathers important information about the deceased, such as whether there was a will or there wasn't, who are the heirs, what are the assets and the debts that exist, And then foundational documents then such as your death notice, acceptance of executor forms are usually prepared at this stage to allow the estates to be reported. And then the next step now is reporting the estate. So the estate must be reported to the master of the High Court in the area where the deceased was domiciled at the time of death, right? So certain prescribed documents are then submitted to the master of the High Court, who then opens a file and gives the estate a unique reference number. We know this is a master's reference. That number will obviously be used in all correspondence from that point onwards. If they ask you after reporting the estate, what do you get? A unique reference number, what we know as a master's reference. So please keep that at the back of your mind. And then we now move to the next step is once the master is satisfied that everything is in order, then they will then issue a letter of executorship. This is also what we call a letter of authority in smaller estates, right? So if your estate is more than 250, it's called a letter of executorship. But if it's less than 250, that's your letter of authority. So now this is very important because nobody is allowed to deal with the deceased estate without the proper authority. This is a document from the master that gives you power to administer, right? So you are legally empowered to act as an executor on behalf of the estate by virtue of being granted one of these letters. And then we move on to notifying creditors, right? So this has to be done by placing a notice in a local newspaper and in the government gazette. So we are then giving creditors at least 30 days to come forward with their claims against the estate. So if you have a bond or whatever that we don't have, that we wouldn't know of, please come forward and tell us that no, the deceased owed you so that we can take that into account when we prepare our account. So this is just to basically make sure that the debts are properly accounted for before anything can be distributed to the heirs. Unfortunately, we must make sure that deceased debts are paid. And then the next step is opening an estate bank account and your asset management. So as soon as money starts coming into the estate, basically, the executor must open an estate bank account. This account is kept entirely separate from any personal accounts and is used exclusively for estate funds. So we cannot still be running from the estate. Or let's say the deceased had an F&B account and then we think money can come into the bank. No, we have to open an estate bank account. And then the bank will usually require like a certified copy of the letter of executorship or authority before opening the account to say that okay, this is a deceased estate and money will be coming in to that account, right? And then after that, then the executor will start gathering information and valuing assets. Remember, like our small Ayana statement, we like value at, This is also forms part of your process. So the family at this stage then starts providing initial details, but valuations from the estate agents, auctioneers, like financial institutions, auditors, whatever are needed. Like let's say there are shares. We can't just take shares at face value. We probably have to contact maybe just auditors, whatever, to give us the share value. So the executor then also lists all liabilities such as the loans, SARS, your funeral costs, your Section 26 of the Act makes it clear that executor must take control of the deceased's asset. So that's why we have after we did our valuing and determining the asset, we go and draw up. And then we also state there in our account that this was valued by the auditor, valued by SARS, no, just like that. Municipal valuation for the houses, all those things. That's where those things come in. So once everything has been valued and confirmed, now we prepare our famous account that we have so mastered called the liquidation and distribution account. We know the L&D at this point. It's basically showing our debts, our assets, and how the remaining balances will be distributed according to the heirs, if any, or intestate succession if there was no will. And then yeah, the account must be lodged with the master within 6 months after the letter was granted, unless an extension has been approved. So if you still need an extension, you have to request an extension for your L&D um, with the master of the High Court if you're not done preparing it. Um, and then inspection and finalization. So when the account reaches the master's office, right? This is our L&D. It then goes to the masters for inspection and finalization. It is carefully scrutinized. They don't play. So if the master finds a mistake or requires like more documents and things like that, they will issue a query sheet, and then you as executor, you have to go back, account or provide further proof before the process can continue. So then once the account passes inspection, it is placed on public display for 21 days. This is known as the inspection period. It lies open for inspection at the master's office and often at the local magistrate's court as well. Those that go to court, candidate attorneys, sometimes you see them being plugged there on the wall, whatever notice board. Yeah. So then during this time, anyone with interest in the estate, such as heirs, creditors, whatever, may raise objection if they are unhappy with how the account has been prepared. If no objections, we are proceeding. Um, And then when all payments, basically transfers, have been made, the executor attends to what we call as the final requirement. So this means basically submitting proof to the master that the heirs and creditors have been paid, properties transferred, shares handed over, the estate bank account closed with a nil balance. And then the executor may then claim their fee, but only with the master's approval. So you don't just claim, you still have to wait for the master. Master says, but the master says basically in estate administration goes, unless of course you can still challenge it at the High Court, but at face value, the master is the one that tells you everything. And then last, filing notice, the master then issues like a final a filing notice. This is like your official confirmation that the estate has been completed and closed, and we are happy. Basically serves as proof to heirs and creditors and even insurance companies that administration has come to an end. So please know this whole process. They have asked questions here and there. Like for instance, they can tell like let's say they ask you something to say around after administering the estate, what preferably what should the bank balance be? It should be nil. These are things that you wouldn't obviously know at the top of your head because we are not all estate administrators, but just know them for the purpose of your exam. And then questions like to which master of the High Court must the estate be lodged? Obviously, where the deceased lived, as I think as candidate attorneys, we know the issue of jurisdiction quite a lot. What documents must be lodged with the master when reporting the estate? I will come to that just a bit later on another lesson. I'm trying to keep my lessons just at 30 minutes. Think of it like what's the difference between a letter of authority and a letter of executorship? Think at it like that. Things like um in what order are the debts and claims paid before heirs can inherit? Know that what happens if the estate is insolvent? I think one of my candidates got that. They did say, how do you administer an insolvent estate? So obviously the Insolvency Act would have to apply. Creditors are to be paid proportionally, and heirs do not inherit. I didn't know this. Remember, I'm not an estate practitioner. I'm the master of an L&D. I didn't know this. But yeah, it's a question that one of my students got last year, and I was like, oh my goodness, I don't even know that. I don't even know the answer to that. But these are things that you just need to brush over. Um, I'm just trying to think at the top of my head. Oh, where will the L&D account lie for inspection and for how long? That 20, 30 days and 21 days. Please understand the difference. So what is the procedure if someone objects to the L&D account? Who makes the final decision on objection? Obviously the master. Things like who will act as the supervising authority for estate administration? Um, things like the inheritance, since the A is a minor, what will happen to inheritance until it reaches majority? Obviously, it will be kept in what we call a guardian's fund until the minor reaches the age of majority. And then we've got name at least three important parties that are important in estate administration. Obviously, executor, your heirs, um, your master. Just try to think at the top of your head. And that's really about it. Ne? And then did I put section 3? Okay, section 3 basically deals with who are the important parties in estate administration. I guess I didn't add that in my slides. But it's just basically, as you know, the important people in estate administration. At the top of the hierarchy would be your master, then the executor, then the heirs, legatee, your creditors, and then other role players like your attorneys, conveyancers, guardians, such and such. So obviously, at the top of your head, you should know that the master supervises the entire process. They issue letters of executorship or authority, examine and approves the L&D, decides on disputes, which is now your objections to the account, ensures that minors are protected and vulnerable. Ooh, my laptop is low and vulnerable dependents, and then executor, obviously they're appointed by the will. If there is no will, they are nominated by heirs or appointed by the master. We will visit this issue later. We like asking the specific section that what does section, I don't remember, I'm not sure if it's section 38, but yeah, what does it say? It basically says that the master can make an advertisement for the appointment or nomination of an executor. If no one comes forward, then the master may appoint someone. But we'll visit that later because we're breaking every section down bit by bit. So obviously, the executor must act with honesty, diligence, and impartiality. Duties include gathering assets, paying debts, finalizing matters with SARS, distributing the inheritance. And then heirs, you obviously know they are beneficiaries of the estate, have the right to be informed of the estate process. Inspect accounts, object if they believe mismanagement is taking place. Creditors, we know these are people or persons to whom the deceased owed money and then they have a right to basically claim during the notice period. And then they must be paid before heirs can inherit. But you don't want to give heirs what belongs to them and then the next thing we tell creditors that, oh, shame. Money is finished. No, it doesn't work like that. And then other role players like your attorneys, conveyancers, transfer of movable property, tutors, guardians, where they're minors, the guardians fund, obviously. We put money in there until they reach the majority age, right? And then attorney, obviously, we are assisting the executor with reporting and administering. So yeah. That is all about it. So I think this was like less than 30 minutes. So imagine if you listen to the 30-minute session every day. There is no way that you would not be able to explain if they ask you questions at the top of your head during an oral, because in as much as it's an oral, they understand that not everyone is in estate administration. So if you can explain it from a general perspective, because I know some of the examiners at times do ask, what does your firm specialize in if you're a candidate attorney? So if your firm does not do estate administration, but you can explain the processes and explain what it's all about at your most general knowledge, there's no way that they would fail you. So please listen, dedicate 20 to 30 minutes every day listening to one video. I think there'll probably be like 10 videos. Then you'll be fine. You'll be well prepared for your oral exam. Nonetheless, confidence and looking good, you will pass your oral. And that's session one. See you again tomorrow for three other subheadings, whatever. Because today I did 2.1, 2.2, and 2.3 of the lead guide. Tomorrow I'm doing 2.4, 5, and 6 of the lead guide. Ganjalo, ganjalo, but we will definitely skip what's this? We'll definitely skip the L&D part because we are fine with that. So the theory basically is not a lot. We're just doing 3 and then get to a 10, then we are done. Interstate succession, I think we also covered in that we do have a quite a number of videos on that. So you should be able to distribute an interstate what's this? An interstate estate. So yeah, guys, love you and don't forget to like and subscribe.